Yes, so by way of breaking news, I'm sure say what see statement from the presidency Honorable Felix Ofosukwache nsa ahyaseɛ ɛkyerɛ clearly say the Chief Justice of the Republic of Ghana, Madam Tokonu Gertrude, has been suspended pending your friend is saying decision so at the committee level or more investigation. And this is say this is the letter from the presidency. Maybe I kind a moon semachro. Actually clearly said the Chief Justice as at the next Tuesday, 22nd of April 2025. She has been suspended. Not permanently, but pending investigation Koso. And the Siamanoka say the senior most justice at the bench on the take over once the Chief Justice is suspended. So as it stands now, Chief Justice Tokonu is no longer the Chief Justice Namum. She has been suspended. And this is the letter from the presidency. President Mahama suspend Chief Justice after setting up committee to probe petition. President John Mahama has, in accordance with Article 146(6) of the Constitution and in consultation with the Council of State, determined that a prima facie case has been established in the respect of 3 petitions against the Chief Justice, Her Ladyship Justice Gertrude Araba Esaba Saki Tokono. Nidin de adoso pa yankanchira ne boa. Di no boa just okoba bi bansa. The president has consequently established a committee in compliance with Article 146(6) of the Constitution and in consultation with the Council of State with the following composition to inquire into the petition which have been referred to them. So Nipana President has set up committee in Omudini Justice Gabriel Scott Pamwan, the first Justice of the Supreme Court, Honorary Chairman. Justice Samuel Kwame Adibu Asiedu, Justice of the Supreme Court, also a member. Daniel Yao Domlevo, former Auditor General. Auditor General Mao William Fee said there was a suffer in the hands of this same Supreme Court. So noted into one of the people. And now Major Flora Bazuanura Dalugo, Ghana Armed Forces. And now Professor James Sefa Zifa, Associate Professor, University of Ghana, member. Pursuant to Article 146(6)(10) of the Constitution and in accordance with the advice of the Council of State, the President has, by a warrant, suspended the Chief Justice with immediate effect pending the outcome of the committee's proceedings, signed by Felix Ofosukwache, Honorable. So this is by way of breaking news. Yakacho said the Chief Justice of the Republic of Ghana, Tokonu, has been suspended. Makacho said President Ewa Huakwenya said once prima facie case has been established, Ninjina said there is merit in the petition. And in this case, we have been told to say 3 different petitions no more come president Ninjina no merit wom. 3 petitions Ninjina could the president and Nimnina no merit ewom. So we are dealing with 3 separate petitions. Anya baako anya mienu. Nti obetime yi wa no baako, obetime yi wa no mienu. Na obeyi wa no miensa no eden. Nti na make say ba bia dun dey ato empaibo na konchene. Only that can save the Chief Justice as at now. And said na Mexico no the process is na man for camp politics in as for no, but it's in line with the Constitution because President J petition, you know, of our day to Council of State. Council of State na crowd there Mpanimfo akese was so immediate past chief, one of the immediate past Chief Justice, your friend is saying Sophia Akufu. I am part of this. So panel now will review to establish this one. No? Former Chief Justice Tusubi, so for them to agree and with the president say he should go ahead and suspend Chief Justice. You know? Clearly, you said some na yakano and some ketwa, and from your friends sources, you know, you could see say in some what petition, no, even though are not public yet, it will be very difficult for Chief Justice to be no. And these are the realities. And like I said, wow, we are Chief Justice.
say ofum mmara and as a momfa mmara kwan you want to have your way, then it means that the constitution and kasana nyadia ubetimi I rely on how I first the year juma. So for this particular process, I've always maintained say I would not be happy if President Mahama be take a decision and in line with the constitution. But once the decision now will take in line with the constitutional provisions. Na your friend saying emra fom bi nemfra mrabia enyanya ne de he should go ahead because we know institutions are compromised and there is the need for us to sanitize this institution to once again bring hope, trust, and confidence. Sabi Ghana for Benya or the judiciary. So where any discussion is by the way of breaking news. Actually say some na yaka ho nsem from nanwa besi nede bia yaka ho asem no. Finally we are here. The Chief Justice of the Republic of Ghana. That is the point I want to make. She has not been dismissed yet. Nambom, she has been suspended pending investigation. And the investigation no ba na say Council of State and as a committee na at this 5-member panel no. Etimi ekase indeed. And some na petition no nyina so. Enti Chief Justice Nzubeba Bakana no asem either she will go there in person or she will go or the lawyer beko. And so the name Mexico, I'm not sure say this woman will meet the committee in person. No, the lawyers in the back hall because nipa na ote panel na Justice Gabriel Scott Poamwan no or no some kind of the way mami we yes ye di nkrofobia ni our Chief Justice our sa Supreme Court ho no ebeya den so obetimi akwatena Justice Poamwan we yanim say on toto na no. I'm not sure the Chief Justice will go. That is just it's a way of positive intuition I may make it. I'm not sure she will go. And this woman, she has a big ego. You know very well. So it will be very difficult for her. Papa we are can say me a senior person. How no young crowd no but a politics in Tino Bending. But they were sidelined. Then I said for over the until recently, we panel and but we know very well, sir, these people no are suffer in the hands of this woman and other people. So when Obia Oshawase now cotton and not to asre na basano and no by a ding. So in the coming days, United, I heard the basic, but Ubisamia, I'm not sure the Chief Justice will have the courage. So Kwakotena Justice for my name any other committee and name I'm here to Tunano. Ebia. Ordinary lawyer no beko that men mayor or no said that Missy Kano. There is no shame in resigning or resigning a shame. Chief Justice, Nyong Kwana why be obia be paying or motifie or be cry the I Chief Justice where we or tifie wayare wu we share no. So one year Chief Justice and nothing will happen to you. Say Nipanos or mom pewa. You don't hang on, won't con giddy. Mamma for position to her resign a coffee. Nka baby ya duru enei ade nchena wo de letter ba abonten kra say processes no momfa ma de Chief Justice me na nya biem ma jai me kofie na obi asom adwo no afa ya ye kotwe wasere na abasa ko process no baby ya duru no there is no way abenya uti adidim considering nsama koso ne pieces of evidence in some amamfo can save yourself, just resign and go home. For me, I think that will save us way because petition I amount for bed drilling more. At this point, the probability is that the petition will leak fully all the three. About amount for I can who the woman no. Ebaya nimguasie. And yen I be who and MPP for now, I'm sorry, I'm my spokesperson, Mokasama cannot save you. You see, these people nanka mempese mekum, but don't forget to say 2025, 2015, Abraham Mahama ye president. Maame na offering Loretta Lamte on an oya shraj boss. MPP for mpanimfo eye akwa we also original parliament or kasa boom another pre ene one nyama a true petition come President Mahama accusing this woman Loretta we na oya shraj boss at the time say wadisika petition no kwa the President Mahama ye all the consultation said the way you go through and at the end of the day the woman was removed by President Mahama. So why be paying and the petition That petition was sent to the president by MPP for Nkrofo Yama or say chairman Sambaka. Well, I will do a detailed analysis of this by way of breaking news. Ama or say chairman Samba ball abaya basa waya they say we shraj boss or free ho. And that year at Tuobia, one of my your friends are guardians of constitution. They have no integrity. So for them, I think we can ignore them for now. But as it stands now, breaking news in this the Chief Justice has been suspended pending investigation. Pending your friend is saying adjudication on the matters our petition.
These members of Parliament are namely Honourable Cynthia Mamle Morrison, Member of Parliament for Aguna West constituency in the Central Region, Honourable Andrew Esiama Amaku, MP for Formena constituency in the Ashanti region, Honourable Kwadwo Asante, Member of Parliament for Suhum constituency in the Eastern region, and Honourable Peter Yaukwachi Aka, Member of Parliament for Amenfi Central in the Western region. 8 grounds have been presented to us in today's application. The submissions made in support of them can be summarized as follows. 1. That the Constitution and laws of Ghana provide no grounds to allow the actions of the Speaker of Parliament while presiding over Parliament to be questioned in any court, including the Supreme Court, because of the doctrine of separation of powers that guides Ghana's constitutional democracy. 2. That because of a circular issued by the Chief Justice of Ghana in 2021 and repeated by another circular issued by the current Chief Justice under the hand of the Judicial Secretary, the service of the processes in this suit on the Speaker of Parliament was invalid. As such, the Speaker of Parliament, under the hand of the Clerk of Parliament, had returned processes served. That whenever there is a vacation of parliamentary seat, and this is identified by Parliament in its proceedings, the only lawful forum for disputing any issue concerning the vacation of seat is the High Court, as provided for in Article 99 of the 1992 Constitution. The applicant urges that no jurisdiction is given to the Supreme Court in such a situation. 4. Because the orders of 18 October 2024 were made after hearing only one party in the suit, and without hearing the Speaker of Parliament, the orders breached the rules of natural justice, breached the rules for exercising discretion provided for under Article 296 of the 1992 Constitution, and were invalid. 5. The orders of 18th October 2024 were made on the basis of fraudulent misrepresentations by the applicant to the court. 6. The substantive action is incompetent because the writ was accompanied by a statement of claim and without an affidavit or verification. The application is opposed by the plaintiff, who is himself a member of Parliament, and the Attorney General, who is a second defendant. We have considered the application. Sorry, it's opposed by the first defendant. Sorry. By the plaintiff. Yeah. Aren't we tired? We have considered the application and find that the grounds supporting the application have no merit because of the very explicit and clear directions of the 1992 Constitution, specifically Article 2, Article 130, and Article 296, and established decisions of the Supreme Court from decades of the country's constitutional history. Below are the reasons behind our evaluation that the application has no merit. Interpretation and enforcement jurisdiction of the Supreme Court. Article 2, on the very first page of the 1992 Constitution, provides as follows. Enforcement of the Constitution. A person who alleges that A, an enactment or anything contained in or done under the authority of that or any other enactment, or any act or omission of any person, that's B, is inconsistent with or is in contravention of a provision of this Constitution, may bring an action in the Supreme Court for a declaration to that effect. 2. The Supreme Court shall, for the purposes of a declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made. 3. Any person or group of persons to whom an order or direction is addressed under Clause 2 of this article by the Supreme Court shall duly obey and carry out the terms of the order or direction. 4. Failure to obey or carry out the terms of an order or direction made or given under Clause 2 of this article constitutes a high crime under this Constitution, and shall, in the case of the President or the Vice President, constitute a ground for removal from office under this Constitution. 5. A person convicted of a high crime under Clause 4 of this article shall A, be liable to imprisonment not exceeding 10 years without the option of a fine, and B, not be eligible for election or for appointment to any public office for 10 years, beginning with the date of the expiration of the term of imprisonment. From the above, it can be seen from the very first page of the 1992 Constitution that the most fundamental and hallowed right of every Ghanaian that the 1992 Constitution gives and jealously guards is that when anyone, including the President and Vice President, is embarking on any act that violates any provision of the Constitution, or if anyone is of the considered opinion that any law or rule enacted by any legislative body breaches the Constitution, that person can run to the Supreme Court for enforcement of the Constitution. That person does not even need to be directly affected by that act or law. This Supreme Court regularly exercises this original and exclusive jurisdiction for citizens of this country. Second, Article 130 provides, 131, subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided in Article 33 of this Constitution. The Supreme Court shall have exclusive original jurisdiction and in A, all matters relating to the enforcement or interpretation of this Constitution. All matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or persons by law or under this Constitution. Where an issue that relates to matter or question referred to in Clause 1 of this article arises in any proceedings in a court other than the Supreme Court, that court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination. And the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court. This means that if anyone finds that a meaning is being given to any provision of the 1992 Constitution that the person disputes, or that any act is being done by reason of a disputed meaning given to the Constitution, then Article 2 and Article 131A mandates that only the Supreme Court has jurisdiction to provide the people of Ghana with the correct interpretation of the provision in the Constitution. Third, it is the most basic tenet of our legal system that different courts operate different jurisdictions, and every court is given its own jurisdiction. So the type of cases that can be settled in any court depends on the nature of the dispute. Thus, if someone is challenging that a member of parliament has not lawfully won their seat, that challenge must be done at the High Court in the region that the constituency is in. However, if any two people challenge that the process of electing the same member of parliament did not conform with the constitutional provision, that dispute over the correct interpretation or meaning of the constitutional provision must be brought to the Supreme Court for interpretation. Indeed, if the dispute over correct interpretation or meaning of the relevant provision occurs while the parties are before the High Court, the High Court must, by direction of Article 132, stop hearing the case and refer the dispute over the correct interpretation of the Constitution to the Supreme Court. There are many cases on this manner of resolving disputes requiring constitutional interpretation, including ex parte Senator Rawlings, citation provided. In every given month and year, the Supreme Court regularly deals with cases seeking interpretation and enforcement of provisions of the 1992 Constitution. And every law report issued every month is filled with such cases. It is therefore misinformation and misapprehension of law for the applicant to present that the Supreme Court has no jurisdiction to provide the correct interpretation, because Article 99 gives jurisdiction over determination of membership of Parliament to the High Court. Article 99 reads, "The High Court shall have jurisdiction to hear and determine whether a person has been validly elected as a member of Parliament, or the seat of a member has become vacant, or a person has been validly elected as a Speaker of Parliament, having been so elected, has vacated the office of Speaker, aggrieved by the determination of the High Court under this article, may appeal to the Court of Appeal." From the above, it can be seen that if anyone raised the question whether a person has been validly elected as a member of Parliament, or a seat of a member of Parliament has become vacant, as a matter of fact, that person is required to go to the High Court for the High Court to resolve any issues around that question. In the instant case, the records brought to the Supreme Court submitted that the question was raised on the floor of Parliament, that by filing nominations to contest as independent members of the 9th Parliament, members of the 8th Parliament should be deemed, by reason of the meaning of Article 97(1)(g), to have vacated their seats in the 8th Parliament. Thus, the vacation of seats is not a matter of fact from death or resignation or notice by the parties themselves to Parliament. It is to be taken from an interpretation and enforcement of Article 97(1)(g). It has been argued by counsel for the Speaker that what the Speaker presented to Parliament on 17th October did not constitute a ruling that was executable or amenable to the controversy raised in this suit. On the contrary, we find that nothing can be clearer in the record from Parliament that was brought to this court and considered before this court's ruling of 18th October 2024 that this was an executable ruling. The Speaker's ruling is headed, quote, "Formal communication by the Speaker." It set out the background of issues he was considering and covers 10 pages of evaluation of law and fact. He concluded by declaring that, quote, "The MPs cannot be allowed by law and my good self to